Honorable KJ is just...
Sorry?
I think it's just a little impatient, but we are all on points of order. Mr. Speaker, I think what Honorable David Ochieng and others are raising are very important, because this is the first time we are coming up with a popular initiative that has reached this level. And I'm glad to hear from Honorable Otiende saying that the Joint Committee has looked into it. I think because of the lack of time, we haven't had opportunity to read, and I'm sure we will read. And I'm hoping that the committee will address them, because even if we don't address them as Parliament, they will be addressed elsewhere. So it would be very foolhardy for us as Parliament to leave our responsibility or raise those issues substantively, either through the report or through the House. Mr. Speaker, based on what they've stated and giving cognizance of the fact that I've not yet had opportunity to read the report of the Joint Committee, I would seek forgiveness if I repeat some of the things they've raised, but which will be okay anyway if they've raised them. My first issue is, Mr. Speaker, everybody has agreed there's a popular initiative, and Article 257. Is there an executive initiative? That's something I would like the Speaker to respond to, whether there's an executive initiative, because there's been a reference to an executive initiative. Does the Constitution, not our conjecture, does the Constitution make reference to an executive initiative? Secondly, is there a ranking of rights by positions? For instance, do I have a greater right to life than a fishmonger in Rusinga Island? Is there a ranking of rights in the Constitution? Against, not by my subjective thoughts. Constitutionally, is there a ranking of rights? Does the President have a greater right to life than I do? Does some other citizen holding, either now or in the past, a senior political position have a higher ranking of rights than I do? Third, Mr. Speaker, on the issue of popular initiative, I would seek your guidance that if during public participation, people give different views, say during the period that they've gone around, the promoters have gone around seeking views, and we have 100 different views in regard to this, Mr. Speaker. Do we then take all their views and bring them to Parliament? Will there be a framing of 100 new questions? And Mr. Speaker, who then becomes the promoter? Is it the 100 people with the different views or the original promoters? And in that sense, Mr. Speaker, how do we deal with the issue that has emanated from the courts about public participation being quantitative and not qualitative? When does qualitative work and when does quantitative work, especially in regard to this issue? Mr. Speaker, the other issue, just two more, Mr. Speaker. Can a constitutional provision that has been moved by Kenyans, that Kenyans have desired, in itself be considered unconstitutional? Mr. Speaker, I hope you're getting me.
Absolutely.
Yes. Can a constitutional provision moved by Kenyans on their own be considered unconstitutional?
Are you saying, when you talk about being moved, are you suggesting, the question is, can a constitutional amendment or a proposal to amend a provision of the Constitution be unconstitutional?
Mr. Speaker, that is actually, I can actually put it in 3 levels. One, can a proposed amendment be unconstitutional?
Absolutely.
That's a different thing. But once it is passed, can a constitutional provision be considered unconstitutional? I'm not talking about where there is a clash. A substantive passing in the Constitution, can it be unconstitutional? Mr. Speaker, Mr. Speaker, my other issue is, can Kenyans, somebody is asking that lawyers are asking very strange issues. The Speaker is a lawyer, he's understanding me. It's not a house of lawyers, but it's a house of passage of law, Mr. Speaker. And Mr. Speaker, I would want to encourage those who are worried. Let me not encourage. Mr. Speaker, I thank you, and I can see my sister Janet, who understands what I am doing, encouraging me. Thank you. Mr. Speaker, those who do not understand, ask me to unpackage for you, because I know the Speaker understands what I'm doing. Mr. Speaker, can Kenyans pass a system of law or constitutional law that is sui generis for Kenyans, that may be a departure of other practices, but is very sui generis of Kenya? Is there something that stops Kenyans from passing a system? Maybe I can give an example that when we are passing the Sexual Offences Act, we were told that minimum sentences are not practiced in the Commonwealth. But Mr. Speaker, what we told them, in the Commonwealth, people were not raping 2-year-olds. So can we pass a sui generis system that recognizes our realities? And finally, Mr. Speaker, when there is an error that is noticed after the passage, how do we balance the role of Parliament? How do we cure it? The role of Parliament vis-a-vis the constitutional interpretation role of the Supreme Court. Thank you, Mr. Speaker.
Member for Soy.
Yeah?
Please, only those issues that require my considered ruling.